Let's talk about how to defend your deportation case by marrying a US citizen. I have a lot of these cases and I have a lot to say about it, but I'm going to try to make this video relatively short. I have posted one or two videos on this topic in recent weeks, and I've gotten a couple consultations from people who really benefited from those videos, from that content. So I thought I would just keep it going until people tell me that they don't care about this topic anyway. So let's say you're in removal proceedings and you entered the US with a visa, or you were paroled at some point, either at the border or subsequently you were paroled in any way. And that includes re-entering the US on advance parole. We need to show that you were inspected, admitted, or paroled, basically so that we can continue with the adjustment of status process through marriage. So if you entered legally and you're in removal proceedings, generally the procedure is file an I-130 and only an I-130 with USCIS, unless you are an arriving alien, which is beyond the scope of this video. You would just file an I-130 with USCIS. You would simultaneously tell the immigration judge and show evidence that you filed an I-130 with a US citizen spouse and that it's pending. You would ask the immigration judge to delay the deportation proceedings, either by granting a long continuance or granting administrative closure to temporarily pause the deportation proceedings. That I-130 would need to get approved. You'll usually need to attend an interview with your spouse. After it gets approved, you're now eligible for adjustment of status, and you can ask the immigration judge to terminate deportation proceedings so that you no longer have immigration court, which would allow jurisdiction for the green card application, the I-485, to rest with USCIS. Or if the judge refuses to terminate deportation proceedings, jurisdiction for the green card application would lie with the immigration court, and you would file the I-485 directly with the immigration judge, and then the judge would schedule a hearing date to make a decision on that I-485. Just quick caveat, it is much more expensive to file the I-485 in removal proceedings, and that doesn't even take into account the fact that you're going to need an attorney, which is going to charge you a fortune for removal defense and adjustment of status at the same time. All right, now, what if you entered without inspection? This becomes much more complicated and speculative, but the first step is the same. You file the I-130 and you ask the judge for more time so that USCIS can make a decision on that I-130. But the next step is you're gonna need a 601A waiver, an unlawful presence waiver. And just like larger level, taking a step back, big picture, the reason you need a 601A waiver is because you entered the US without inspection or without proof that you entered legally. And therefore, you have to eventually go back to your home country for an interview at the US embassy or consulate. At that embassy or consulate, you get an immigrant visa and then you re-enter the US legally. That is the procedure if you've entered illegally. Generally speaking, I don't want to overgeneralize, but for 95% of people, that's the procedure. If your only issue in the US is that you've entered without inspection and you're unlawfully present in the US for more than a year before you begin this process. So since you're going to have to go back to your home country, you are likely to trigger a 10-year bar the moment you leave. And the reason for that is if you have more than 1 year of unlawful presence in the United States, the moment you accrue 365 days and you leave the US after that, that departure triggers a 10-year bar. So if you don't want to get stuck at that consulate for 10 years, you need an unlawful presence waiver to be granted before you leave. So your unlawful presence will not trigger this bar. And for that, you need to get an approved Form 601A. The problem is immigration judges under current policies don't want to give you enough time for a 601A to get approved. Current processing times on a 601A, you could check on the USCIS processing times website, but it's like more than 30 months. It can take up to 3 years to get an approval. And there's no way an immigration judge is going to give you 3 years right now unless you're in one of those jurisdictions where cases are just taking forever to process. And your final hearing date might be 5 years out in the future. If that's the case, then a 601A could totally be viable, but it's fact specific. And for most people, it's not a great option right now. But anyway, let's say that it's ordinary times, not the Trump administration. What you would ordinarily do here is you would get I-130 approved, show the judge it's approved, and now you've filed a 601A waiver. You ask the judge to pause the case or administratively close the case until a decision is made on the 601A. If the 601A gets approved, you're good to go. And now you can either terminate the removal proceedings so that you can continue with the consular process abroad. You can't leave if you're in removal proceedings. That will cause you to get a final order of removal. Or alternatively, if the judge doesn't want to just terminate, you can apply for voluntary departure. It's technically a defense from deportation. The judge has to grant it, but they generally will if you don't have criminal history or any super adverse stuff going on in your case, like immigration fraud, multiple illegal reentries, or major other immigration issues. The judge grants voluntary departure. You leave during the window where the judge grants it, and if you comply with that voluntary departure order, you don't receive a deportation order. So you generally now have a clean case with no removal order, and unlawful presence will not deny your visa from getting granted at the consulate. You go to the consulate, do your medical exam, do your consulate interview, get your visa, re-enter the US as a permanent resident. The day you use that visa that the consulate gives you to re-enter is the day you become a permanent resident. Then you'll pay the immigrant visa fee, and the physical card will get mailed to your US mailing address within like 120 days, ballpark. So that is the procedure for doing it if you've entered the US without inspection. We have a ton of these cases right now where people entered with inspection and without inspection. And we're trying these strategies in different courts nationwide. So far, it's mixed bag. Some judges are giving us time to pursue these I-130s and 601As. Other judges are not. And some judges, their patience is wearing thin because we've just been asking for more and more time so that our clients can get these cases approved so that they have more options in the future. This is a constantly evolving situation, constantly changing. So even by the time I post this video, there might be some minor changes to our strategy. Anyway, guys, if you're dealing with this situation and you need any immigration assistance with family-based green cards, citizenship, or deportation defense, you could always schedule a consultation with me, Pouyan Darian. I'm an immigration attorney handling these cases nationwide, and the first step is to schedule a consultation by clicking the link in the video description below. Thanks so much for watching, and I'll see you next time for another informative video.